What's up, everybody? And welcome to the start of another trial. And as most trials begin, it is with jury selection. James Crumbley is on trial about a month after his wife was convicted of involuntary manslaughter connected to their son, who was the Oxford school shooter. And what's interesting about this case is being the second case of a high profile nature creates a lot of different obstacles that's going to make it very different from Jennifer Crumbley's case, even though it's going to look very similar in a lot of different ways. We're going to have similar witnesses, we're going to have similar evidence, but it's going to be more difficult to pick a jury. And it's going to be an interesting angle to see how the first trial affects some of the arguments both sides make in the second trial. Because both sides watched, both sides learned what worked, what didn't work, and where they can point out the differences and potentially even more culpability or fault on James Crumbley than existed for Jennifer Crumbley. Because we know potentially that he was the one that purchased the firearm, maybe taught Ethan how to use it, and the one responsible for securing the firearms. And maybe even more of that journal will be discussed. It seems like more of it's going to come in because some of the statements specifically were Ethan crying out for help for his dad specifically and not his parents together. So we're going to have to watch and see how that evidence is presented. But today we're going to focus on day one of jury selection because that's where we're at. Tuesday, March 5th. They started jury selection. They didn't even get the jurors up there till 10:30. Very slow start. It seems like questioning didn't really start until after lunch around 12:30. But that's not so unusual. A lot of things happen at the courthouse, and we're going to talk about them today. When we think a jury is going to be picked, when we think this case is going to start, how long we think it's going to go for, and kind of our schedule of videos for it. So make sure you guys hit that like button and subscribe to our page if you haven't already. If you're going to follow the James Crumbley case, let me know in the comments. A lot of you asked for this, especially when the Jennifer Crumbley case was winding down. So we're jumping on it. We're going to break it down. We're going to recap. We're going to talk about the lawyering, what's being proven, what's not, how the first case will affect this one, and so on and so forth. But as we start with jury selection, in every case, there are similarities. The court system can be slow, especially when you have a lot of jurors. You got to figure out where to put them. They've all got to go through the questionnaire. They've all got to go through metal detectors. They've all got to be put in rooms. They've all got to go through videos that explain jury selection, how it works, what their duties are, what their job is. And then usually the judge questions the potential jurors, and then each lawyer gets the opportunity to question potential jurors. In this case, some jurisdictions, the judge asks all the questions. But here, both lawyers get to ask questions, and we're getting updates from a local website, which we're going to give a shout out here as we go through some of the details that they have reported on in day one. But generally speaking, in a case like this, there will always be some background questions. When there's a high profile case connected to this, or just it's connected to high profile news reports, as it was, a lot of questions will be focused on that. And the judge set out from the beginning that we're not going to find a full jury of people that have never heard about this case, but that's not the standard. The standard is, does your knowledge about this case create the scenario where you can't be fair and impartial? Do you know too much? Have you already picked a side? Have you already made up something about James Crumbley's guilt or innocence in your mind before you sit down here today? Because you know that Jennifer Crumbley is guilty, potentially, does that mean that you think James Crumbley is guilty? Is there stumbling blocks that the defense is going to have to get over that they shouldn't because they don't have a burden? All of those questions were asked to these jurors. And if anybody said the defense or even the state starts out a little bit behind the other side, then they can't be fair and impartial. They will be struck for cause. Now we know because of all this attention, James Crumbley's attorneys have asked for a change of venue, and that was denied by the judge. But the judge did do a couple things. Number one, the judge allowed extra jurors to be gathered for this trial, which means we can expect jury selection to take longer because everybody knows that there are extra jurors. My last trial that we talked about, we busted the whole panel of 35 potential jurors, and we only had 20 left to pick from, and it was 5 o'clock that day. So we didn't end up getting to pick a juror. I have heard the potential jurors for this case are in the hundreds. I believe they sent 200 jurors home in the middle of the day yesterday to come back this morning, March 6th, so that they could start and continue to question each juror. Now, there are different ways to do this. I believe they're putting 15 in the box, asking them all the questions, cutting some as it happens, and they'll shuffle them in and out, kind of waves of jurors. We've seen it done different in every case, but that doesn't really matter as much as the fact that nobody's going to be afraid to strike jurors, because sometimes when you know you're getting down to the end of the jurors, it's like, well, are they going to be okay enough for us to pick them and just start this juror, or do we start this trial, or do we really think they're going to be fair or unfair and partial toward one side or the other? That shouldn't happen in this case. So the judge allowed them extra jurors because the judge can limit the jurors to a reasonable amount to pick. You can't just get the entire county to show up so that we can pick a jury for our case. We don't get to do that in just normal car accident or wrongful death cases where we're going to trial on them. So the judge allowed that in this case, which I think was appropriate. And she also allowed additional preemptory challenges for the defense. That's how I've seen it reported. I didn't see the actual order. It's interesting if the defense gets more preemptory challenges than the state, or if they're allowing both sides to have extra preemptory challenges. I've also heard it reported that it might only be one additional preemptory challenge. So what's a preemptory challenge? Well, we talked about cause challenges where if they admit they can't be fair and impartial, they're going to get struck. There's unlimited challenges for that. And the judge, the state, the defense usually agree on that, or at least the judge agrees with one side when they say that's a cause challenge, judge. We know they can't be fair and impartial. Probably somebody that's been the victim of a shooting. Can't be fair and impartial regardless of what they say. It's just tough to put that out of your mind and sit for this type of trial. But a preemptory challenge is a challenge either side can strike a juror for any non-discriminatory reason. So they can't say I strike them because they're male or female. They can't say because of the color of their skin or their racial background or ethnicity or their religious beliefs or political party. You can't strike people for those reasons. But you can strike them because you say, I didn't like the way they looked at the defendant. That shirt that they're wearing makes me think they're not going to be partial, or they're going to be partial against my client. I don't like them. I'm not going to pick them. The color of their shirt. I mean, it can literally be anything sometimes, and I've heard some crazy reasons for preemptory challenges. So the defense is going to get extra of those than what's normally allotted, which allows them to strike more people that might be borderline cause challenges, which allows them to try to flesh out who they believe might be colored by Jennifer Crumbley's trial, coming in knowing too much. Because it can be that it's like, well, they said they watched her trial. We don't want anybody with that trial. We're going to use a preemptory challenge, even if the court and the state don't agree that that should be a cause challenge. So that's kind of the background here of when we get into jury selection in this case. We also know that it's going to be a 2-week trial. That's the schedule. So knowing they have a lot of jurors, knowing they started on Tuesday, they probably want to start this trial at the latest next Monday, which would be March 11th. In my opinion, I think it'd be great if they could at least pick a jury and maybe do opening statements by Friday so we can start witnesses by Monday at the latest. Maybe they'll be able to start sooner. I think that would be great. But with hundreds of jurors and recognizing the issue because of the publicity of Jennifer Crumbley's trial, that could be difficult. The judge also told the jurors at the outset that she could sequester them throughout the whole trial, but she's not going to at this time. So will that be something she considers in the future? I don't know. We'll have to wait and see. So let's get to some of the specific reports, which I think are interesting topics of conversation for us to get to for Clicked on Detroit. Click on Detroit is the local website that's doing a really good job of posting what's going on here and kind of the stuff they're talking about. And we'll go through some of the topic areas they got to day one. Gun ownership, obviously. Asking questions about it. A lot of jurors own guns and have no problem with them. But some of the jurors say, I would never own a firearm, but I could still be fair and impartial. Those are the types of answers that the defense has to sit there and be like, okay, do they think anybody that owns a gun is wrong? Because that's not true, and that's not legally correct, and that's not what the law is. So they've got to try to parse out sometimes as a lawyer is jurors are saying something, but based on their nonverbal cues, maybe you have a jury consultant that's helping you, a body language expert maybe that's telling you they're not going to be good for anybody that owns firearms, which we know James Crumbley does above and beyond what was used in this case by his son. Oxford Strong. They're asking, do jurors have Oxford Strong signs and t-shirts? And the answer is yes. And that on its own is not going to be enough for a cause challenge. Probably, depending on what their answers are. But will it be enough for the defense to strike them to think they're too sympathetic, in this case, against Ethan Crumbley? And will they attach that to James Crumbley? Those are the types of things. And that's why I want to talk about this. So you know, what are the lawyers thinking, regardless of what the answers are to some of these questions? Deeply sad details of the shooting. Of course, they're going to get into that. Everybody agrees. With that, that's not what they're here to decide. They talk about the Jennifer Crumbley trial coverage. If anybody watched it, about 6 jurors in this group, not in whole. They're handling it in groups. Matthew says, and this is the judge, it's a very different case. All of those jurors assured her that they watched that case, they can still be fair and impartial. Now, the judge will ask these initial questions, but it's up to the defense attorneys to dig in more, see if they've really made up their mind because they watched Jennifer Crumbley's case, and get them struck for cause if they've already convicted James Crumbley before his trial has even started, because he was obviously married and in a similar situation to Jennifer Crumbley. It's up to the defense to sometimes pull that information out so the judge will see, yes, they need to be struck for cause. And if they're not, or the judge doesn't think that, but the defense still thinks they need to be struck, they need to determine if they're going to use one of their preemptory challenges. They're not unlimited. I don't know the exact number they have in this case. In most jurisdictions, it's somewhere between 3 to 6. So I'll have to look and see how many they actually have in this case. You guys might know in the chat. You can post it if you do. So after the judge asks those preliminary questions, again, about sometimes they'll ask connections to law enforcement, which they asked here. Have you ever been a victim of a crime, gun ownership, Jennifer Crumbley trial, publicity, things like that. Then the lawyers get to ask questions. So here's Karen McDonald, the state, getting to ask questions. So the first group with 15 in the box, so it seems like they're only asking 15 at a time. They excuse some already for, again, scheduling conflicts, things that come up in every case, right? If it's a schedule conflict, then they can't be on the jury. What other ones? I think I talked about them already. Law enforcement, victims, things like that. Oh, and then obviously, if somebody immigrated to the United States and English is not their first language, sometimes it can be difficult for them to keep up with all the legal terminology. It may be very important. Sometimes they can be struck for cause. Usually there'll be a discussion for that, but this juror says she thinks she can keep up and understands exactly what's going on. So that's not an issue. IT worker said he knows about the case from just a few headlines, but he doesn't have social media and he is skeptical of what he sees on the news. So just from my experience as well, picking jurors, this is a lot more common than it was 5 or 10 years ago, that people are more skeptical about what they see on the news and social media. Again, grocery store worker here has something like, he said he would never own a gun, but he's indifferent about them. So if you think that's somebody who's going to be negative toward anybody who owns a gun, you might want to strike him as the defense. But this is probably not enough for a cause challenge. 12 of the 15 jurors that they're asking questions to right now say they watch the news on TV. Then we get into some mental health questions. We know that came up in Jennifer Crumbley's trial, probably going to come up in this trial. Some of them have experience with it. And one man specifically said his cousin was shot by her son who was suffering from mental health crisis. To me, this is probably enough for a cause challenge. So what do? Do they just strike him right there on the spot? Usually not. Usually they wait until a break. The lawyers get together with the judge. They talk about it. They say, we think this juror probably should be struck. If everybody agrees, sometimes the judge will let that person go and they'll fill in the box again. Now, what's frustrating and cumbersome about doing it this way, and I don't love it, I like doing bigger groups at a time, but then you got to re-ask all those questions to the next person you shuffle in. So I don't know if they're just doing these 15 until they strike maybe all of them or some of them and then bring another 15. But whenever you have the fill-in process, sometimes that can get difficult because then you're like, okay, again, victim questions, law enforcement questions, scheduling questions, English as a second language question. And to me, that wastes a lot of time. And the other jurors are just kind of sitting there. And you don't want to rush through those because they're very important. So if it sets up a scenario where you rush through them, that's not great either. There was a teacher who said that she has an elementary school son who deals with students who might deal with mental health issues, doesn't own guns, but grew up around them. Okay, so here we go. Next juror doesn't own any guns, but said they are legal as long as they are stored safely. They have no problem with guns. So a follow-up question I would ask to this juror is, what is your definition of stored safely? You got to dig into that, see what they think, and see if they think any gun not locked in a lockbox, unloaded, taken apart, whatever it may be. If they believe that there is a level or a standard that's not necessarily proven, not the industry standard, maybe you can strike them for cause. But if they do believe this, and they think that flat out is going to be something that is negligent and they're going to convict James Crumbley because we know it probably wasn't stored properly, then maybe you want to use a cause challenge for that strike, to strike that juror. And you can tell the judge if they ask for a reason that they've already made up their mind, you feel like, based on that answer. You don't have to be right about that, which is interesting. But your feeling as a lawyer is they've already made up their mind. We don't want to take the chance. We strike them with a peremptory challenge. You're going to be allowed to strike that witness. Now, this is why you got to balance how many you have and when you want to use them. An engineer with General Motors said he doesn't watch the news, doesn't go on social media. Basically, he lives under a rock. Then the state ends questioning for these 15 jurors. So it's going to go back and forth. We're going to have judge, state, defense for every set of jurors. So McDonald ends. All 15 say they can be fair and impartial. So she's asked everything she wants to ask at this point. And it wasn't very long. Court takes a short break. During that break, they send home 200 jurors. So I don't know how many are actually sitting in the courtroom, only 15 in the box. There could be another 30, 60, 90 in the courtroom, but we know there's at least 200 more coming back today, the day you're watching this video. All right, court comes back, and now Lehman, the defense attorney, asked the school teacher if he knows how to spot mental illness or moody teenagers. He said he can spot moody teenagers, focus on guns and mental health. A father with 2 children, aged 12 and 9, has 2 guns that he keeps locked up. He said he doesn't have strong opinions about gun ownership, but people should be responsible. Lehman asked if the only way to be responsible was to secure a gun with a safe. He said no. He agreed trigger locks would be another way. So these are the exact type of questions you want to ask as a defense attorney to try to figure out where the standards are, where the lines these potential jurors are. It's tragic. One woman told Lehman she's heard a lot about the case from talk at work, and when asked about her opinion, she said it's tragic. So you got to dig in. Where does that put you? How does that make you feel? Potential juror on guns and mental health. Another juror said he owns guns, he's had guns pulled on him when he was a child, but he uses a gun to protect his household. He does go to the shooting range. I do not like it when I shot it, really. Man said his cousin was suffering from mental illness when he shot his mother. Lehman asked if there are times when someone can be having a mental health crisis and you don't know about it. He said it depends. The man said listening to his cousin give him clues. He needed to try and provide help. Photographer said he owns a Ruger at home, keeps it locked in a safe. She said if people like guns for hobbies or protect themselves, they should be allowed to own a gun. Most of our kids aren't trained at a range. It's a shame. So again, you hear these details that we get from these potential jurors and you apply them in your head as the lawyer to the case. You know that this minor was trained at the gun range. So maybe she would think that was a good thing that they were training him. Maybe bad. Shooting range questions. Potential juror asked if children 12 and older should be trained if they know there are guns in their home. Lehman said in order to ride a snowmobile, someone has to be trained and licensed. Juror said she has no problems with parents taking their teenagers to the range. Getting more information. One potential juror said she served on a jury that found a person charged with homicide acted in self-defense. He said guns aren't for him, but he doesn't have anything against them. So past jury experience is also important. Are they able to come to decision? Are they able to be able to stick to their guns? And they're able to say not guilty. That's a big one for the defense. Confusion about access questioning. Lehman asked a line of questioning about access to certain things inside a house. There was some confusion for both the judge and the jury. That sparked a long back and forth about access. One juror told Lehman that she was confused or she was being confusing. So you never like that when, and I've had jurors do that to me before too. Like, are you hiding something from me? Why can't we talk about insurance in this trial? I'm like, sir, the laws in Florida allow us to talk about certain things. They don't allow us to talk about other things. Like, well, now I think you're hiding something from me. And that's never good because generally people don't like lawyers. Generally, they think lawyers are slimy. And when lawyers say we can't talk about something that's obviously part of this case, which is very frustrating for me, I wish we could talk about insurance, but I can't tell him that. And maybe here they're like, you're being confusing on purpose. That's never a good sign. Lehman is trying to explain that access to things inside a home is different of children of different ages, but the jurors appear to be lost. Perfect parent. So we know this is a common defense here for the Crumbley parents that they were not perfect parents. But does that mean they're criminally negligent? That's for the jury to decide. She asked jurors to raise their hand if they think they're perfect parents. So we didn't do this on Jennifer Crumbley's case. But if a lot of parents say, yeah, I'm a bad parent, or I'm not a perfect parent, or we got to give grace to parents, it's probably a good thing for the defense. People that think they're perfect parents, probably good jurors for the state, because they'll expect other people to also be perfect parents and have a higher bar. She asked them if they made mistakes or wrong decisions. She then asked them to raise their hand if they think they do their best. Most agreed they do the best they can. I would go further and push on this, especially after watching the lawyering, the closing argument, and a lot of the plan and strategy of Jennifer Crumbley's lawyer. I would want jurors to think they're bad parents or think that they screw up a lot. Or parents that don't think that they are responsible for all of their children's mistakes. You can ask questions like that. I would push that bound. Teenagers and affection. Lehman asked jurors with teenagers to raise their hand, and if they love affection in public. 2 jurors raised their hand. And she asked if they should force affection on teenagers who don't want it. Don't know what their answers were. Asked the jurors if as a teenager they told their parents everything. Most said no. It's another good question. She asked how often any of them keep things from their parents or lied. Most raised their hands. And this is important because when you're strategizing and making your arguments in your opening statement and closing argument, you know what these jurors think. You know if they're with you and that teenagers don't tell them everything. If they're with you and that teenagers don't always show affection. If you can't always spot mental health issues. So you know that, and you're looking in each of these jurors' eyes, knowing how they feel about these potential topics. Back and forth between prosecutor and defense attorney. This was interesting to me. So you can object and there can be some arguments. Usually you don't want it to be in front of the jurors. So I don't know if this was at sidebar, obviously enough for this reporter to hear it, that she told, the defense attorney told jurors they're going to see and hear emotional evidence from inside this high school. She said James Crumbley's son shot those people, not James Crumbley. McDonald interjected that James Crumbley was at a meeting where he was presented with his son's worksheet, which contained disturbing drawings. Judge Matthews jumped in and said during the back and forth, it says Judge McDonald, but I think it means Prosecutor McDonald jumps in and the jurors are taken back. So they have this exchange, it seems like, in front of the juries. So McDonald says James Crumbley was at the school at the morning and played a role in the crimes, which drew a gasp from some of the potential jurors. Matthews jumped in to say that Lehman meant the jurors need to be able to judge James Crumbley separately from what happened inside the school. So it seems like McDonald's trying to almost pre-try this case saying, no, James Crumbley was involved in this. And the judge is like, whoa, that's up for the jurors to decide. Lehman is setting up an argument that James Crumbley is an imperfect parent, obviously, but not responsible for the shootings. One juror said he didn't know how he'll feel seeing the shooting since he's a volunteer EMS. Doesn't know if he'd be a good juror. Usually if you're the defense there and he says that this stuff may really have an impact on him, you want to make sure he gets struck for cause. You don't want to find this out later in the middle of a trial and have to strike him later. McDonald clarifies James Crumbley isn't charged with being a bad parent, but with failing to provide ordinary care, and the failure led to a result that was foreseeable. So again, it seems like she's pre-trying the case a little bit. The juror said he wasn't sure if he'd be a good juror after seeing a video of the shooting, was excused. So they played a video. It's interesting. Oh no, I'm sorry. This was just part of the argument. Yeah, okay. He was excused, and I believe that's the right decision. They're being sent home, and they start back up today at 9 a.m. So I think it's really interesting to hear from these potential jurors specifically. What are they saying? What do they feel? What are some of their backgrounds, right? So we know this. We can continue to break this down if you guys are interested in it. And if you are, let me know in the comments. If you just want to wait till we have a jury and start breaking it down during opening statements, that's fine too. But you guys are always the ones that pick what content we're going to be breaking down. To me, it's interesting. What do the lawyers do with this information, and how can we apply it potentially to the arguments they make and the evidence they present in the case? And that's why I thought it was kind of cool to look at what these potential jurors say while we have access, thanks to this local website. And we will continue to do it if you guys want it. Actually, before we go, we have some updates from this morning, March 6th, on more juror information for what they have to say about what they've seen and what they know about this entire Crumbley situation. Same website, day 2. Both sides, the defense and prosecution, have agreed to excuse several prospective jurors based on the answers to the questionnaire that was filled out Tuesday morning. In one case, A woman wrote that she has followed the shooting and the criminal cases closely. She wrote that she believes that James Crumbley is guilty. This is the exact information the defense is looking for. They want to know. They're not mad at this juror. They're happy that she's being honest and telling them. And this, if they would have had a slew of jurors answering the question this way on the questionnaire, then maybe they'd have an even better argument to change the venue. So we'll keep an eye on this because we've only been through 15. Actually, they've probably been through a lot more questionnaires. But we're seeing that this is an answer at least some jurors are giving, which is what the defense is worried about with this jurisdiction and why they want to change the venue. Next, they bring more prospective jurors into the courtroom. The same group of 15 sit in the jury box with one exception. One woman replaced the juror who was dismissed before the end of the day yesterday. She's a human resource worker. So they are doing the scenario that I talked about where they're replacing one juror when they need to. And now they're going to have to run through all of those questions again with this new juror sitting in the box. So, new juror answers the questions from the judge, said her father and members of her family have dealt with mental health issues in the past. She said there were shotguns in her home because her family member owned them. She has no problem with people who own guns. On the trial proceedings, she said that she didn't watch the Jennifer Crumbley trial, but she saw reports on it on the evening news, and she's not formed an opinion on James Crumbley. Again, you've got to be wary of this if you're the defense attorneys and try to figure out if you believe she's made any connection or any decisions like the prior juror that we just read said that she had on the questionnaire. Now, Karen McDonald asked questions, made a few points about following the evidence, telling the juror members that they have to make up their decisions based on what's presented in trial. Then the defense attorney asked questions. She asked if she knows everything her children did when they were teenagers. Juror said no. Lehman asked if the juror bought a car for her children. Does that mean giving access to the car? Juror said no. Just because you buy it doesn't mean you give them access. Talked about presuming people innocent. And what's the verdict right now if she asked? The juror said innocent, which is the correct answer right now as we sit here. Defense attorney asked if she feels like she needs to hear from James Crumbley. Juror said no. Clearly, that's not something that you can force on the defendant. The defense dismisses a juror in seat number 7, the high school teacher. New juror steps in to take his place. So boom, we got to do it all over again. Asked juror about himself. His marketing company has 3 children under the age of 10, so no teenagers. Didn't follow the Jennifer Crumbley trial, just the verdict. And again, that's tough for the defense. If all these people know that she's guilty, are they going to automatically think James Crumbley's guilty? More from the new juror. The juror told the judge that he can make a decision based on the evidence. He agreed that when Lehman asked if he would sometimes tell his parents different things as a teenager, he agreed that sometimes he did things that his parents didn't want him to do. Sometimes he got caught. Sometimes he didn't. That's all important because that's going to be kind of the defense's strategy here. Defense attorney asks if a child took the keys to a car without his parents knowing and something happened when he was driving the car, should the parents be held responsible? The juror said it depends on the situation. He probably should not be held responsible, but this is a hypothetical. So again, some good instincts by this juror for the defense, if you're the defense. And then drunken driving hypothetical. So as attorneys in jury selection, sometimes you can give hypotheticals to try to feel how the jury would make decisions with different scenarios. The defense attorney asked if someone hurts someone else while driving drunk, should the parents of the drunk driver be held responsible even if they don't know they took the car? The juror said they should not be held responsible in that scenario. Lehman asked if the parents should be held responsible if they knew the child had been drinking. And the juror said, probably. So how is this going to apply to the facts and the law in this case? That's what the lawyers have to determine when picking these jurors. Lehman told the new juror he would be seeing a video from the school. That they would be, and the juror said they will not see James Crumbley in the school at the time. The juror said if he can separate the two, the shooting and James Crumbley, the juror said yes, that they can separate the two. Then they're eliminating a couple dozen jurors just by the questionnaire. So we know that they've already had 200 plus here. These are probably even more jurors that they're sending out questionnaires for. And they expressed an opinion that James Crumbley was guilty or that they followed the wife's trial very closely. So jurors are admitting, multiple jurors admitting that they followed Jennifer Crumbley's trial very closely, and multiple jurors also admitting, not necessarily the same jurors, that they believe James Crumbley is also guilty. So if a couple jurors are saying that, that's got to scare you for the rest, because there are going to be some that just don't say it. They feel bad about it. They feel like it's not the right answer, not the appropriate answer, so they're just not going to say it. And that's something that's scary to a defense attorney. describing the scene in the courtroom. Jury box is full with 15 prospective jurors answering questions from the judge on both sides. Then there are 5 rows of benches in the courtroom that are filled with prospective jurors who can take the place of the jurors who get dismissed from the box. So sometimes they're hearing the questions and answers and back and forth. Sometimes that can affect their answers. Sometimes it doesn't. It's always an interesting way that different jurisdictions pick jurors. Prosecution and defense teams are in front of the courtroom at their tables, and there are smaller benches for the media to the right of where the jurors are waiting. There are about 40 to 50 prospective jurors in the courtroom. So that answers a lot of the questions we had at the beginning of the video. Another juror dismissed. She said she doesn't own a television, has never heard of the Oxford school shootings. She was replaced by a man who appears to be in his 20s. So interesting. I don't know why she was dismissed. New juror's boss linked to the shooting. New juror said a boss of his was affected somehow by the shooting. He isn't sure exactly, but he heard some small talk about it at work. He said his relationship with his boss could be affected by this trial, so he should be dismissed. New juror then said being on the jury wouldn't affect his work. He said he would have no problem finding James Crumbley not guilty. McDonald clarified that the juror would be able to find Crumbley guilty too. He said, yes, that's interesting. I think he should be struck. The high school teacher who was dismissed earlier in the day was replaced by a retired registered nurse. That's interesting. Always interesting when you have injuries and damages and deaths. Any medical personnel, certain jury consultants and lawyers will feel certain ways about that. I appreciate you joining me. Make sure you hit that like button before you leave and subscribe to our channel. Hit that reminder bell if you're going to join along with us for the James Crumbley trial. But for now, that's all I've got. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.